Hi, I'm Greg Dell with Dell Disability Lawyers, here with attorney Stephen Jessup, and this week in our Answer Questions by Our Lawyers, we're going to talk about Unum disability appeals. And Stephen, Unum's the world's largest disability insurance company, so we tend to get the most questions about them. We'll go back and forth with some of these questions. Certainly want to invite claimants to go on our website, go to the Answer Questions by Our Lawyers section, ask questions, or certainly always call any of us for a free consultation where we'll be available to answer questions, discuss an appeal denial, and provide some solutions that could hopefully get them back on claim and also help prevent a denial in the future. First question is that people want to know is, I've been denied, but Unum was paying me before. Do they have to continue paying me while my appeal is pending?
Unfortunately, no. And a lot of times for people, they find out that their claim's been denied when the benefit check didn't come, and they're like, I have rent to pay, I have a car payment, all these types of things, and the money's just cut off. And since Unum doesn't have to pay you during the course of the appeal, now if you win your appeal, they have to pay you all the money they owe you up to that point. I think that's also part of the reason why, if there's a denial, some people rush to get their own appeal in, because Unum's like, they'll say like, hey, just, submit a letter of appeal disagreeing, and someone else will take a look at it, not explaining the importance of the appeal to someone, and people will rush at thinking, oh, this will get my benefit, reinstated quickly. So that's one of the worst things about these. Now, sometimes, Unum will, even though it's very rare, especially if you're in a own occupation period, usually the initial 24 months, and it's going to transition to the any occupation. Every now and then you'll see, well, Unum, say you're going to transition to any occupation definition disability in July, they may tell you in March, well, we've conducted our review and we've determined that as of July, et cetera, date,
Right.
You're no longer, so you do have some time there, but more often than not, most people find out their claim's been denied when the check didn't arrive.
Why does the law and why does Unum offer 180 days to submit an appeal when someone's like, you just cut me off, like you're saying, I can't pay my bills, but yet you expect me to take 180 days? Besides the fact that the law says you have 180 days, why is it so important to not rush the appeal like you were just saying?
Yeah, it's your only opportunity at this point. So people understand the importance of the appeal. Under ERISA, the law that governs these policies, you have one opportunity to appeal. Unum doesn't give you a voluntary. You get one shot at it. And this is going to be your last opportunity to submit additional information that supports your disability, any additional testing, information from doctors, things like that, for Unum to consider. Because if they deny that appeal, at that point, as of the date of that denial, your what's known as claim file, it closes. And your claim file is just everything that you've ever sent them or they've ever created. And for purposes of filing a lawsuit and litigating this case, that claim file, that closed period of time, that's the only thing a judge is able to consider when it comes to determining whether or not Unum made the right call on the case. So your appeal is your last chance, right? If you rush the appeal and you don't get additional testing that could have supported why you can't do a sedentary job or testing to supporting your complaints of cognitive problems, you may be forever barred from doing that. So with that, Unum, if you just say, hey, I'm appealing this decision, I think you've got it wrong, which, I'm working on a litigation case right now. It's a handwritten letter that says basically just that. Unum was very kind to say, all right, our appeals department looked at the information and they agree with the prior decision to deny. Nothing new was submitted with it. Now she's in a position where if we had done the appeal, there's testing I would have had done without even thinking, without question right away. Now we're barred, right? And her doctor was even saying, well, yeah, I could see that she could maybe work under these restrictions and limitations. Not once did she get something from her doctor to clarify those statements. So now it's going to go in front of a judge, and that judge is going to see, wait, your doctor agreed with Unum's decision. What are we arguing over here?
Right.
So rushing the appeal can really, really, decrease your chances of, A, getting back on claim, but then even then, winning or prevailing in court, or even having them, negotiate any type of reasonable settlement.
So once you prepare this entire appeal, which can take you on average anywhere from 60 to 180 days if you have it, depending upon the facts and circumstances of a particular client's case, what is actually going on at Unum once they get it? Meaning, how are they going to go about reviewing this particular appeal that you submit in order to determine if they're going to reverse or uphold the denial?
Yeah, so once it's submitted, it goes to their appeals department. Unum is notorious for using in-house doctors to review cases. Sometimes, hiring, independent peer review doctors to take a look at it. It's very rare. I mean, I can't remember the last time I've had Unum want to do an independent medical evaluation after an appeal's been submitted. So you can expect that they're going to have either their own doctors look at it, and yes, there's an inherent conflict of interest, in that the whole appeal process there is, but that's the way that it goes, or a potential outside doctor who's going to review your file, likely will certainly never speak to you, and may actually never speak to your doctors and render an opinion about whether or not they think you're disabled, and you may not find out really anything that's going on until Unum under law has to provide you, with those reports. So normally during the appeal, you submit it. They have 45 days to make a decision. They have a 45-day right to an extension. You might get a letter that says, "Hey, we've had your file reviewed by 1, 2, 3 doctors. Here are their reports. You have 10 days to respond." To these reports on it. So you may not get anything after you submit your appeal except for an acknowledgement, and then any negative, reports from their doctors. Unum isn't very well known for touching base and keeping you apprised of what's going on.
Does Unum have to have the claimant examined by one of their doctors or any doctor for that matter?
No, they don't. Now the policy gives them the right to, but they don't have to have you examined. They can rely on their own in-house doctors or independent peer review doctors that are hired. The law is fine with that. Courts have said there's no requirement they send you for an independent medical evaluation. There's no requirement that they give more weight to your doctor's opinions, which seems crazy considering your doctors have actually examined you, spent time with you. They're allowed to rely on doctors who are just going to review your file.
But how does a doctor who has never seen the claimant at all really know about this person's functional restrictions and limitations and ability to show up for an employer 5 days a week, 8 hours a day, 40 hours a week? How
$1,000,000 question. That's the million. How? It's a good question. How do they? And I even find a lot of times doctors don't even get to the vocational aspect of it, right? They say, "Hey, doctor, what do you think?" Say if it's a back problem, chronic pain, what do you think are restrictions and limitations? And if that doctor says, "Well, I think that this person could work at a sedentary demand level, sitting, lifting, this and that," they don't necessarily ever go to the doctor and say, "Do you think this person can do the duties of this job?" Right? They take, "Oh, doctor said they can do sedentary," and then they send to their vocational department. Vocational department goes, "Oh, here's some desk jobs we think that they can do." So don't expect that their doctors are going to necessarily understand what it is you did, because Unum's not necessarily feeding and supplying that information. Where that information can be found is documented in your medical records, any additional testing that's going to be done to support, impairment restrictions and limitations and stuff. So you have to, be of the mindset of how would you present this to a doctor who may not know, doesn't know anything about you, because they're just going to look at the records. And if the records are silent, you haven't had good treatment, your doctors aren't taking good notes, they're not going to give you the benefit of the doubt of thinking, "Oh, this may be what's wrong." They're just like, "Well, it's not here, so everything must be okay."
Right, and it's sad because it's contrary to the way that doctors are taught right when they get to medical school. One of the first things, not that I'm a doctor, but I know from having friends that are doctors, is they tell you right away, "Look, you're going to learn a lot of things here about what goes on in charts, but we'll tell you right now, you treat the patient, not the chart." But yet the way insurance companies do things is we evaluate the chart and we don't care about the patient. So not everything, and it's well known. A doctor, you would never call the doctor and say, "Hey doc, should I be able to work? Or can I work? Or am I okay to go back to work?" All the doctors say, "I can't tell you that, you need to come in." When was the last time someone called and they said, "Oh sure, well just send me how you're feeling and send me the records and I'll tell you if you can go back to work"?
Yeah.
It doesn't work like that. But in the insurance company world, it works like that, unfortunately. Now, our cases, if they are to lose the appeal, are much stronger when we go to court, because we're able to argue to say, how does this one doctor just looked at records, ignored 2, 3, 4, 5 different doctors who've been seeing them for years, like you were saying, and doesn't know anything, never even spoke to this claimant. So clearly, if you have to weigh the evidence and you're a judge who's a human being, you're going to say, well, these 5 people saw this person, this one person just looked at records, who am I going to side with? So it's surprising insurance companies don't do it more to look at a claimant. And even when they do look at the claimant, they usually don't do it right. But it's just surprising they don't do it more I'm thankful they don't, because it makes it better for claimants to have a better chance if they were to lose their appeal. Along those lines of having an independent quasi-doctor who finds that a claimant's disabled is when you have claimants that are approved for Social Security disability. And even though they're approved for Social Security disability, Unum still denies them. Does Unum have to agree with Social Security disability?
No. So it's to be considered strong evidence in support of disability, but they don't have to abide. Just because you get awarded Social Security doesn't mean that they have to pay benefits. Just recently, I saw a gentleman called me. His appeal had been denied. He did it on his own. He was awarded Social Security while his appeal was pending. He submitted that information to Unum. He even repaid them the money that he owed under the policy instead of waiting to kind of see how his appeal would play out. And Unum ended up holding that, yeah, well, we got that, but we understand that they say you're disabled. We don't think you are under the standards of our policy because we did X, Y, and Z, and that information wasn't available to Social Security, so that's why our decision is different. So yes, it's certainly evidence in support of disability. We argue it, but that in and of itself doesn't mean an insurance company has to pay you. And even in court, judges will consider it, but just because you have it, the judge isn't going to side with you and say, oh, Unum, you did the wrong thing here.
In these Unum claims, once you submit them, how long does it usually take Unum to make a decision on appeal?
So they're going to get 45 days as an initial review period. The law will afford them one 45-day extension for showing a good cause. What exactly that means is open for interpretation. So you can expect, more often than not, I see a lot of times they do an extension. Even if they take the extension, doesn't mean they're going to use the whole 45 days. One other thing for consideration, why it's also important to try to have everything ready in your appeal to submit. Anytime you submit additional information after you've submitted your appeal, it's going to toll the time that they have to review to give you an answer, because they're allotted the ability to review that information and speak as to it. So it's really important, if you can, to get everything in. Now, if you have updated treatment, something really good comes in, you want to have that because this is your only opportunity. But I would say you reasonably expect 45 to 90 days. It's not often, I can't recall a time necessarily off the top of my head where Unum had a decision prior to the 45 days being up. Whether they drag their feet period of time or, they don't get to it, at least you're going to be in that first 45-day period.
And when Unum does a internal medical review or sends the claimant out for an independent medical exam or compulsory medical exam, they will send copies of their reports to the claimant or to the claimant's lawyer. Do you always reply to those?
It's an interesting question, because I find that normally, yes, reply to the first one, but then you can get into this where then they have their doctors reply to your reply, and they'll try to drag this out, and at some point it's like, nothing new to add, please conduct, finalize the review on it. So in a lot of ways, yes, because if not, you'll see in denial letters, in reviewing someone's appeal denial letter, they'll say, oh, we provided you this information and, to have your doctor's comment, we didn't hear back. So they almost like silence as acquiescence. So I do think it's important to give some response, to it. Always, I'm sure there's a time that I haven't, just because I didn't feel it was necessary.
Right.
But depending on what it is, yes. And sometimes they'll give you, reports from multiple doctors, and some of them aren't really relevant to what you're trying to push for disability. So you just focus in on the important aspects of it.
Yeah, I think sometimes it's also strategic in how you reply, because sometimes you can say, look, if I have this arbitrary and capricious standard review, if I were to lose the appeal, I see this doctor completely ignored this particular information. And then you got to have this conversation with the client to say, look, I think right now, if I don't say anything, they're probably going to deny you, but I think we're in a good spot to win the lawsuit. If we reply and bring up this particular issue, they may go and address that and still say, we don't agree with you, and now we've taken our ace in the hole that we want to argue in litigation. So I think sometimes that comes up, and it's a real strategy call in terms of what you're going to do.
And from my experience, once you've gotten those reports, and they're not doing it out of the goodness of their heart, there's Department of Labor regulation changes that require them now to give you the opportunity to respond. remember, the response you're doing is going back to the doctor who just said you can work. There's
Right.
nothing wrong with you. So it's very difficult. More often than not, I level with clients. I say, when we receive these, you can expect they're just checking the boxes, and then a denial is going to be imminent. So like you said, then it becomes a strategy thing.
Right, because a lot of our clients, we're very honest with our clients, and we'll say this is an indication that they're leaning towards denying the claim, and they feel this pressure to say, well, we got to get A, B, C, D, and E, and often we've already done that, but certainly we will try to continue to put in additional information if we see that opportunity. So it is a good time to be able to provide additional information if something exists. So this was, scratching the surface on Unum questions. We already have, there's probably 80 questions plus on our website about Unum specific. If you're someone out there who has Unum questions, feel free to submit them on our website or call Stephen, myself, or any of our disability lawyers. No matter where you live in the country, we're available to assist you, and we'll always provide an immediate free phone consultation.